Good afternoon. Um, Good afternoon, and I uh, apologize for those who are joining us from the 11 a.m. tutorial. Um, Obviously, I did not intend for this to happen, but it is what it is. And we'll do our best to manage. So, how are you guys doing this afternoon?
I'm okay. How are you?
Good,
Just one.
thanks.
I was doing a lot better 2 hours ago, um, but I've managed to sort things out and move the day forward. So, okay, so let's start by checking in and just seeing what um, what you guys learned in the lectures last week. So, what do you feel like you got out of the lectures last week, and what still isn't clear to you? Shasia, if you had something you wanted to say, you muted yourself again. So I don't know if that was
No, I was thinking, but I think I'm clear on everything.
okay.
I don't,
So
I'm,
what did you get out of the lectures last week?
oh, last week we did Juicy of Care. No, we went to Breach of Juicy.
Hmm.
Um, what did I learn? That I'm not sure right now.
Who else wants to jump in? There's not really a wrong answer here, guys. So this is just me checking in to make sure that are you guys aren't getting lost and uh, aren't willing to say anything. So this is your chance to say something if you're feeling lost. Nothing? Okay. Then we will take it from here and we'll jump off into this week's tutorial question. So the question, which if you'll recall, is available on e-learning on the page marked tutorial questions. And the question is, I'm going to put it in the chat for you. Discuss the ways in which policy considerations shape the definition of the duty of care, right? So recall that for tutorials, our questions will be reaching back 2 weeks and we'll be checking in on the week on 1 week ago. So check-ins are for last week, tutorial question is for the week before that. So what do you guys have for me on this? Let's start by asking, what are policy considerations?
Sarah, say in the case that you work with somebody, do you think like the rules are things that you would have in place to take care of your employees?
Well, I mean, those are, yes, that's a policy, yes. But when we're talking about judicial decision making, what are policy considerations?
I think it's whether the plaintiff should be compensating based on the circumstance, or if the defendant. Well, I mean, that's basically, okay, never mind.
Okay.
Yeah.
So what, anybody else want to take a stab at it?
Good morning.
Good morning.
Policy consideration are considered with whether the plaintiff should be compensated or the defendant prosecuted from or protected from liability.
So, I mean, that's correct as far as it goes, but it's also so broad that it encompasses the, analyses of causation and fault, right? So it goes, so that's a definition that's so broad that it doesn't actually give us anything helpful in how to discern what policy considerations are doing in the duty of care. So let me ask you this, okay? In the Toombs case that we read, right? The doctor in that case relied on a precedent called McKay to argue that he should not be liable. What was the argument in McKay for why the duty of care should not be extended to that case, and why? And from that, like, why did the doctor argue that he was not under a duty of care in the Toombs case?
For that case, the doctor didn't say that he didn't have a duty of care because his patient was the mother, not necessarily the fetus.
Right. That was the common law issue, right? But there was a statute that created a duty of care to the unborn children. But what was the argument in the McKay case for why there was no duty?
So you can repeat the question, please?
Sure. In the Toombs case, right, that we discussed a couple of weeks ago, the doctor argues that this McKay precedent forecloses liability because in that case there was no duty of care, and so there was no duty, and so his case was just like that one, and so there was no duty of care for him. What was the reason why there was no duty of care in the McKay case? Keandre says, wasn't it something along the lines of negligence? All of this is negligence, right? Everything that we do is in negligence. So Keandre says he did not provide negligent advice to the mother to cause the defect to the child. So the answer, that's the answer in the Toombs case, right? That's the doctor's argument in the Toombs case. But in the McKay case, right? No. You're right. No, that's not the case. That's not the case. Both doctors were inarguably negligent. Okay. Absolutely. The issue in the McKay case is that to impose a duty to recommend termination in this circumstance, which was the duty that the plaintiff wanted imposed. The plaintiff wanted to not have been born, right? And the to impose that duty would put doctors in the position of advising clients to have an abortion in order to mitigate liability. And the court in McKay, right, said that that was improper, right? That was not an appropriate incentive to create. Okay. So the court absolutely could have created the duty, right? There absolutely could have been a duty to advise that your child cannot be born normal and healthy, and if that is important to you, you should be considering a termination, right? But for policy reasons, the court said, we are not prepared to put doctors in that position. So this is what a policy consideration is. Right? Policy considerations are when the court opines on the effects that its decision will have beyond the effects on the parties before the court. Okay? It can fit, right? Shasya says it kind of fills gaps. That absolutely can be a role that policy considerations plays, is as a gap filler in the court's analysis. But ultimately, policy considerations are about where the court is asking what happens in the next case. So that's what policy considerations are about. So put this back in the chat for you guys, right? In what ways do these larger considerations, these considerations of issues beyond the parties before the court, how do they shape the boundaries of the duty of care? Keandre says they create the argument for proximity, and I would like you to flesh that out a little more. Can you explain that in more detail, please?
Okay, so what I was thinking was the fact that if the court is going to look at a case in front of it and consider future cases, one of the things that they would take into consideration is this a situation where the breach of the duty caused an effect that in the future, I can foresee when somebody else comes along the line that this is something that is likely to happen? Or is it just something that is just so far that even though it happened in this case, it is very unlikely that it would happen again?
So this is sort of like the argument that I was making yesterday regarding the Wharf case, right? That finding a duty in that circumstance was improper because the events were so unlikely that they were not foreseeable. I think that is definitely, like, the remoteness analysis certainly comes out of courts engaging in policy-oriented analysis in terms of, where are we going to draw the line, right? How are we going? So you're absolutely right that remoteness is one way in which the boundaries of the duty of care are drawn as a policy matter, right? There's no legal argument for remoteness except for this doesn't seem right, right? It doesn't seem right that you can knock, you can set a Rube Goldberg machine in motion, and at the end of it, you're held liable for the egg that breaks, right? So I think that's one example. What else can you guys come up with?
Also, doesn't it? Oh, sorry.
I just asked you a question. Sir, could you expound again on your point that remoteness draws a boundary on the duty of care?
Right. So the as a matter of logic, there are no limits to but-for causation. Okay. There's no point where in every case, no matter what has happened, we can cut off but-for causation, right? The end of that chain is always a fact-driven inquiry. But that also means that you can draw a but-for line that goes on, like, you could make an argument for holding, trying to think of an example. You could make an argument for holding the government of Haiti responsible for all of the property losses that French landowners lost when the Haitians, won their independence. Spoiler alert, that's exactly what happened. You all know that, I'm sure. But you can continue that chain of causation on forever, right? So remoteness is a doctrine that says at some point we're going to cut off the chain. We're going to say this earlier event, this earlier negligent act no longer causes this downstream effect because it is too attenuated in time.
Thank you. That I understand.
From your tone of voice, I'm not convinced that you do.
Oh
but
no, I do. I was writing it down. So
okay, I'm just
saying that remoteness cuts off the extent of liability.
right. And so, and please don't think that I was criticizing you. I was just going, okay, are you just trying to get me to shut up?
No, I understand. It's good.
Good. All right, Jade, you had a comment you wanted to make just now. I'm sorry.
I was just saying that when we look at policy consideration in relation to duty of care, it also opens a way for the boundaries of duty of care to be flexible and more subjective. Whereas you still have standards, but on a case-by-case basis, due to the facts that you get, you would give a decision that would be appropriate to the situation and future situation.
Yeah, and I think that's absolutely correct. And I think Shasi is saying something similar, that policy considerations widen the duty of care, but also ensures that impossible or unreasonable duties aren't placed on defendants, right? So we have, the development of res ipsa, right, grows out of policy considerations where it's improper to leave the plaintiff to bear their own injury, but it's impossible to determine how the plaintiff was injured, right? What was the negligent act? And so res ipsa is an expansion of the duty of care, right? in order to protect plaintiffs, in order to protect injured parties who are who would otherwise have no recovery because they wouldn't be able to prove the negligent act that harmed them. And the flip side of this comment, right, the impossible or unreasonable duty, you know, this is very much like the wrongful life theory of cases, right? That's, you know, that's a point where judges are saying, as a matter of policy, we are not going to recognize this type of claim, right? You know, the Wharf case that we were talking about yesterday, and you guys will learn very quickly that case names are the one thing that I just never remember. And that's part of why I don't insist that you guys remember them. It's certainly helpful if you do, but as long as you know the concepts and the ideas, the case names are secondary. But the Wharf case was an argument, was a case where, you know, this Rube Goldberg causation series led to a lot of damage that the court said, look, it's clear that this was caused by this negligence, but nobody would have seen all of this coming from what happened with them. And so we're not going to impose liability. So thank you, Danielle. The Wharf case is Wagon Mound number 1. So Keandre asks, can someone argue that it makes the duty of care more rigid? Well, how would you make that argument? This question isn't just for Keandre. If anybody else wants to jump in, you're more than welcome to. But the question is, could you argue that policy considerations make the duty of care more rigid?
I think it would make the duty more rigid if they apply this consideration, because if they say, okay, well, here's the checklist or the principle to apply to say, if the defendant conducts this act or omission, then there is definitely a duty of care. So that would create a standard, like a specific objective standard to cases. But if in considering this policy, they say, you know what, we won't apply it because then it's going to, by extent, impose that specific duty, all cases, like you previously said, and that could create issues. So when making that consideration, if the court decides that, like in the McKay case, if they decide they're not going to apply that principle to make that binding liability, then yeah, it would limit liability, limit duty of care. Sorry.
These all seem like good points to me. Rashana says, can it be said that it attributes responsibility to the defendant as well as seeking to ensure that the defendant has a fair chance of proving themselves without imposing an unreasonable and far-fetched duty? I mean, I think that absolutely could be a way to describe it. I think that all of this is very much the same sort of, these are all the same kinds of statements, right? That would be the balance of probabilities principle, right? The idea is that we're trying to make sure that, since at the end of the day, the methods of proof are about persuasion, right? It's about what you can convince someone is true. And that's what all of the rules of evidence are designed to do, is to give you ways to convince people that something is true. Then, you know, the idea is that if the balance of probabilities is saying that if you are convinced that the plaintiff's story is more likely to be true, then they should be compensated for that. So, I hope that it's starting to become apparent, like, just how intertwined with this body of law policy making and policy considerations really are, right? This isn't a body of law that sort of like descends from the heavens on 2 stone tablets. Sorry, that's a Mel Brooks joke, and it's a lot funnier when he tells it. Anyway, the law doesn't come from God, right? It comes from us. And so all of these choices were choices that were made by someone for a reason in the past. And one of the things that's important for us as lawyers is to be able to think about what were the reasons that motivated these earlier decisions, right? And so that's part of why we're asking this question about how do policy considerations shape these boundaries? And I think you guys are doing really well with this. So the other thing that you were asked to do in preparation for this tutorial was to have an example in mind. An example of a situation where the common law would not impose a duty, but your policy preferences would suggest that it should. So who has an example that they can offer us?
I don't know if my example is correct, but this is what I had. That perhaps if someone was drunk driving and crashed, and say a lot of metal pieces like released from it, and there was this bystander who was a war veteran and he had PTSD, but say for about 5 years he was healed from it, he was doing fine, and then as a result of the crash and the metal and stuff, it brought that back to him and he's now suffering from it again. Could that be?
Okay, well, let's pick it apart, right? I think this is a really great example. Thank you for offering it to us. Let's sort of deconstruct it and ask ourselves what we think. Okay, so let's start with and I see the private message, and we'll come to that when we finish this one. Let's start with what claims would the plaintiff be asserting in this situation, right?
I think psychological damage.
So this is a negligent infliction of emotional distress claim,
Yeah.
right? Is the term that is used, that I was trained to use. Still negligence, and the damages are a psychiatric injury. Okay, so what do we know about the limits of psychiatric injury in the Caribbean? This isn't just for Shasya, anybody can jump in.
I think that the person they can't have been currently suffering from it. They can be something that happens frequently.
Keandre says it has to be more than mere stress. Shasya says that it has to be something that's created by the negligent act, right? It can't be a past psychiatric disorder that is exacerbated by the negligent act.
Sir, not
Yes.
to cut you, sorry, but wouldn't the eggshell rule apply in that case?
That's where I was thinking. is that this seems to me to be an application of the eggshell rule, which we'll either talk about in lecture tomorrow or next week. I can't remember exactly where it is in the chapter, but it's definitely in the reading for this week and next week. I'm just not sure where it falls. But the one sentence version of the eggshell rule is that defendants can't argue that they're not responsible for the fact that their negligence exacerbated a pre-existing condition. Okay, they can't argue that if you hadn't had the pre-existing condition, you wouldn't have been harmed. They sort of take their plaintiff as they find them. So I'm not sure that the pre-existing condition rule necessarily applies. Maybe it does. Maybe I'm wrong, but that's not my instinct, because I know that the eggshell rule is fairly prevalent throughout the Caribbean. So what else do we know about psychiatric injury?
Wait, sir, can I ask a question in regards to the eggshell principle?
Sure.
Okay. So, in Smith v. Leachbrain, the defendant was liable because the plaintiff burnt his lip as a result of the defendant's negligence in the workplace. And what the judge stated was that employers are liable for all consequences of their negligence. And I feel like that quote right there to say that you're responsible for all the consequences of your negligence creates a very broad spectrum for liability. And
I'm inclined to agree.
Then,
yeah, go ahead.
And then he went on to say the victim's predisposition to cancer and the results of the injury didn't matter, because even though the defendant couldn't have reasonably foreseen the specific sequence of events that produced the damage, they're still liable for the general results of their negligence. And I understand that because the eggshell rule and the whole taking your victim as you find them was always an established law, it's not affected by the rulings of the Wagon Mound case for negligence.
Mm-hmm.
But I still think that the things called principle, while it exists as a separate principle in law, that I guess you could say is somewhat supreme in most cases, I feel like it gives a certain standard of liability, irrespective of what the actions that took place were. Because while I understand how the employer would be liable for negligence in the workplace, yes, but to say that they would be responsible for the death that occurred, that seems like a bit of a stretch. Because the defendant was predisposed to cancer, and then they died about 3 years later after the initial injury.
Yeah, that seems to me to be an error in the court's reasoning as to causation or as to remoteness, rather than an issue with the principles of law, right? I think that the argument, I think that it sounds like, and I may be wrong, I don't want to put words in your mouth, but it sounds like the issue that you're having is that the court in this case found liability in a situation where you're not convinced that the causal chain exists. Am I understanding your point correctly?
No, I understand the ruling for this specific case, but I feel like if you're applying that principle, wouldn't that also be a policy consideration for the eggshell principle? When you're applying it to other cases, I feel like it creates a certain standard of liability, irrespective of specific facts of the case.
Yeah, absolutely. So there's this concept in legal scholarship of the anti-canon, right? So there are decisions that are the canon, and not the canon like boom, but the canon as in like canonical literature. And just off the top of my head, right? Donahue would represent torts canon, right? As would Caparo, right? These types of cases. The Holland v. Haynes on the breach issue, right? On causation, right? So these are all things that are sort of key cases, right? That's the canon. The anti-canon are cases that are so wrong that we never discuss them, or we only discuss them to discuss how wrong they are. And it seems to me that it is possible that over time, a case that sort of creates this statement of extremely broad liability could become relegated to the anti-canon, right? It could become a case that just sort of never gets cited, never gets mentioned, only ever gets discussed in the context of how wrong it was. But this is, these are social influences that take place over decades. So we don't know if that will develop, how that will develop over time. So okay. There was a private message. Okay, so this is sort of returning to the question of places where there would be no duty to act, but maybe policy should suggest that we create one. Taking a hike alone, but somewhere along that trail, someone else who happens to be hiking gets hurt, and you choose not to help because of the lack of the Good Samaritan principle in the Caribbean, right? So this is asking about the possibility of imposing a duty to rescue. So what do we think about this?
I think that kind of goes back into the whole principle of the law balancing the rights of the individual versus the rights of the democratic majority.
Mhm.
Because while you might have, well, I would rather say, while it's morally acceptable to extend your assistance to somebody in danger, if so extending that assistance could put you in turn in danger, or you have to go out of your way to execute that duty, then you should be able to make that choice for yourself to say, no, I don't want to do that. Because, like as you said previously in another class, that the instance where if you want to be a superhero, then you have to have the tools. And if you fail in conducting that duty, then you're liable for the results of that offense. And I think that creates a very unfair standard of liability, because you're trying to assist someone, and because you failed in assisting them, you then become liable for whatever harm occurred.
Yep.
So,
I think that's absolutely right. So private message asking to repeat the question. So the question is, we've had suggested a duty to rescue, right? And I want to emphasize that a duty to rescue is a little bit different from Good Samaritan laws in jurisdictions that have them, right? A Good Samaritan law doesn't impose an affirmative duty to rescue. What it does is it relieves you from liability if you choose to act. So it's saying that, okay, you can try to be a hero, and if you weren't prepared for that, we're not going to hold you to it. Okay. So that's the sort of traditional understanding of the Good Samaritan laws. The other issue, right, is a little bit different, of the of saying that everybody has to try to be a hero. Okay, so so what do we think is, and I think Danielle's right that the scope of the duty, right, creates, sort of how we define that duty to rescue becomes an important piece of the puzzle. And yeah, I think you're absolutely right. So Danielle says that she thinks that scene in Regina v. Inston, where if you're the only person who would know of a certain condition or problem and you cannot assist, notify someone who can. And I think that's right. So Inston, for those of you who don't recognize the name, like me, and had to Google, Inston is a case where the defendant was charged with manslaughter because she lived with an elderly sick person who was incapable of caring for themselves, and she did not care for the elderly person and in fact made a point to not care for them. So I don't know that it was necessarily, I don't know that the duty identified in Inston is necessarily as broad as sort of, the duty to stop at a car accident and make sure that everyone's okay, or, whatever the scope of the duty to rescue would be. But certainly under these specific facts, right, as Danielle points out, if you're the only person who can save someone, you absolutely have a duty to either take action or to make an effort, or to alert someone who can take action. So I think that's right. Okay. So what questions do you guys have about today's discussion? Yeah,
So
I think so let me just, because when I post these recordings, they don't necessarily have the chat. So let me just, there's a comment in the chat, right, that Inston is a duty of care that is about special relations, and I think that's right. So I'm sorry, go ahead, Keandre.
No, what I was saying is that what this kind of sounds like to me is like, at least in the Caribbean, it's somewhat like voluntary assumption of responsibility. Because what you create is a situation where we may even use the same, where we see a car on the side of the road on fire. Because the reality is, if you pass and you stop, it puts you in a situation where you would automatically know more than anybody else who would have seen the car on fire and passed. The mere fact that you stop, you kind of get more insight. Like, okay, who is in the vehicle, those type of stuff. So in a sense, you put your way, or you put yourself in a situation where you are somewhat privy to, even if it's just a little more information than somebody who just ordinarily passed. So then for me, it creates a situation where I come out of the vehicle pretending to be a superhero, and I don't have the requisite tools. at the end of the day, I in a situation like this, let's say that person dies, obviously I would be somewhat liable because I attempted to help, and the rule that we had, and then that puts society in a place where the next time, although it's not likely to happen, the next time I see a car on fire, I'm gonna automatically pass that car because I know, okay, I don't have the requisite tools to help this person.
Right. I think that's a really important point. I think that really helps sort of clarify the issues at stake here, right? That if we want to impose, right? So the flip side of imposing an affirmative duty to act is that you have to relieve someone of liability for their actions, right? As long as their actions are reasonable and within the scope of the duty, right? There can be no liability, even if they ultimately fail to help or actively harm, right? So that I think is an important trade-off to keep in mind, is that imposing an affirmative duty on someone means that you can't take issue with how they act, right? As long as it's within the zone of reasonableness, whatever that means. Okay. What other questions before we wrap it up?
When I was going through the test of foreseeability for specific intent crimes, I kind of observed that the law gives more leeway for the test of foreseeability for specific intent than it does for the test of foreseeability in negligence. Because for specific intent crimes, all you have to prove is, well, all the jury has to assess is if the defendant had appreciated that death or serious bodily harm was likely to result from their actions. And so basically it's just, well, just again on a balance of probabilities, that did the defendant know that this would have been a natural consequence of their action, and how probable was it? And then in tort, it's more so a bit rigid, because now you're assessing the foreseeability based on all of these policy considerations, I guess you could say, that have been established in other cases that, like we were mentioning before, kind of creates a rigid structure. So while in criminal law, it's more how likely the consequence is, and the whole probability of the likelihood and foreseeability kept being shifted in the different cases, from Harum DPP to Maloney to Hancock to Nedrick to Woolen. And everybody keeps kind of adding their parts as to what intent is and how foreseeable that intent could be, establish liability. But I still think that just because the only two questions that the jury has to ask is, was this a natural, probable consequence? And did the defendant foresee this consequence? But for tort, it's, instead of it being subjective to the case or for the jury to decide, the courts will simply say, well, here's the checklist. And if you meet this checklist, then you're negligent.
Well, you remember, right, that the Robinson court was very clear that none of this is a checklist, right?
Yeah.
These are all, these are all mechanisms whereby courts are supposed to reason from prior precedent rather than an attempt to, like, check a series of boxes. And I don't know that I don't know that I disagree with your analysis, because I'm not I'm not an expert on criminal law, and so I don't I don't know much about that, but I can say that that in general, power preserves power, right? And in the criminal law, on which side does the power lay? Lays on the side of the state, right? And so it is not unreasonable to expect that judges in the criminal law will look to find ways to lower the barriers to the state's exercise of power. In tort law, where does the power lie? Well, it depends, right? Torts can be committed against anyone, but very frequently a tort case involves an individual suing some entity that has significantly more resources and power. And so if you buy into this framing that power protects power, you would not be surprised to see that courts will be looking to close the doors on torts plaintiffs in a way that they would open them to the state in a criminal prosecution.
That makes so much sense.
So,
that made so much sense. Wow.
So this is part of the price of being a social scientist who studies courts, is that you start to realize that judges are a lot of times decisions in search of reasons rather than reasoning to decisions. So we're out of time. We're out of time. So if you want, Danielle, if you want to continue this conversation, you're more than welcome to email me or come to office hours, but I'm not going to hold everybody else here. I hope that this conversation has been helpful to you guys. I certainly appreciate your engagement and your enthusiasm. So I will see you guys tomorrow, and take care, and bye.
Bye.